This is our Zoom Power Hour with Marshall Grainer on title insurance made simple. Marshall is a realtor and attorney. He practices law at Grainer and Grainer in Horsham. He's the principal author of Pennsylvania's Uniform Plan Community Act. He's a member of the Montgomery, Pennsylvania, and American Bar Associations and of Community Associations Institute. He's also a fellow in the College of Community Association Lawyers. He holds Pennsylvania and New Jersey licenses as a real estate broker and title insurance agent, as well as a Pennsylvania real estate instructor. He frequently teaches continuing education courses for real estate professionals, attorneys, title professionals, and community association managers. And Marshall was the prime mover behind Pennsylvania's Act 54 of 2023, which provided a method to nullify discriminatory deed restrictions recorded against Pennsylvania real estate. Marshall, I am going to turn it over to you now. Thanks, Marshall.
Okay, hi everybody. It's interesting not having at least a few people in front of me, but so be it. I love these lunch and learns, and I just want to call out to Beth again, thanking her and the other sponsors who sponsor these so that BCAR can have these lunch and learn programs, which, as I said, I think are important because I've taken a few and learned a lot from them as well. So, title insurance. Why do we have to have these things? Do the buyers have to pay so much money? Do they really need to do it? And why do you, as the licensee, really need to understand this? There was a time way back when I got my license in the Neanderthal ages when we real estate folks pretty much did everything in the transaction. And as the larger companies have come along, things have been bifurcated so that many of the larger companies have their own title agencies, and you have a conveyancer or a conveyancing group or an outside company that you hire to go over all that conveyancing stuff. And we, as licensees, take a back seat to it. I'm here to tell you that's a really big mistake. As a lawyer and as a broker, if you're not reading and understanding the title reports that you get, whether you represent the buyer or the seller, you're making a mistake. It can blow up in your face and cost you personally or your firm a lot of money because of the mistake that's made. Give you an example that happened right here in Bucks County. I was the attorney. This was a couple of years ago. I don't think the agent involved is on right now, but I won't say anything bad because it all worked out really well. But I was asked by a colleague across the state to help help his daughter and son-in-law to buy a property in Bucks County. It was a farmette. It was a farmhouse and barn that had been subdivided off of a larger property, and Toll Brothers built pretty houses all around. And the buyers were urban people, but they wanted to be suburban people, and they liked horses. They wanted to be able to ride and do wonderful things with the barn and the house. And I happened to know that. When the title report came in, I, their lawyer, read the report and I said, there's a homeowners association here. The seller's disclosure doesn't say anything about a homeowners association. The listing never said anything about an HOA either. And when I went to the listing agent, she said, there's no association. And she went to the seller, and the seller said, there's no homeowners association. But guess what? There was. How did I know? Because it was recorded and it's on the Schedule B2 of the title report, and it says there's an HOA. Well, did it matter? Usually, a homeowners association means you get to vote in elections, you get to serve on a board, you have to pay fees every month or every year, and there are rules that apply to your property. This was an odd situation where there was no vote and there was no fee. But the rules and regulations of the association still applied to the property, and one such rule was that you could have household pets, but no other animals. These people specifically bought the farmhouse and barn so they could have horses and ride them around, and the homeowners association said you cannot. Uh-oh. Now, Fortunately, I do a lot of HOA work. I knew the lawyer for the homeowners association. He didn't know that this lot was part of the HOA, but actually it contained all of the stormwater management facilities for the whole neighborhood of 60 or 80 lots. So, surprise, the buyers would not have wanted to go ahead with the purchase had we not been able to do some things with this homeowners association to allow them to keep their horses and other things. How did it come up? I read the title report. How would you know that it was there if the seller didn't know and you're the listing agent? You could only know by reading the title report. Had the buyer gone ahead and had the agent said, "Oh yeah, this is just fine," and don't worry about it, it's just normal kinds of recorded documents, there would have been a lawsuit involved because when the HOA would tell these people you can't have horses on our property, and that was their only reason for buying this $1 million plus property, it would have been your fault, right? Ultimately, it's your responsibility. So we're going to talk briefly about what is title insurance, and then we're going to go through a sample of a title commitment, which is also called a title search, which is also called a title report. And we're going to go line by line and discuss what does this stuff mean, because it all looks so gray and boring, and it's not gray and boring. So let me share my screen and give you a short PowerPoint on everything you could possibly want to know. Hello. Uh, about title insurance. So, we don't want to be there. We want to be there. Okay, we're working. So, title insurance made simple. Yeah, we'll do our best to make it as simple as we can. So, what is title insurance? Title insurance is weird. If you buy insurance, normally you're buying to protect yourself against something in the future. Fire insurance is for a fire that could happen. Auto insurance is for an accident or a theft that might happen in the future. Title insurance is for things that happened in the past, and you get no coverage whatsoever for things that could happen in the future. That is strange, but it does cover for legal disputes and things like forgeries or somebody claiming that you don't own their property. If anybody here was involved in what happened in Holland, PA, maybe 15 or 20 years ago, I think it was it George Foreman's family that said that he owned all of these subdivisions when people in the subdivisions were living there already? It got very interesting, and the title companies had to step up, or there would have been a huge loss. You pay a one-time premium for title insurance. Again, unlike auto insurance or life insurance or health insurance, you only pay once, and it covers the owners forever, even after they no longer own the property. Again, a very strange concept, but it works really well. By the way, title insurance was invented in Philadelphia, Pennsylvania, about 1865. And the reason was, up till then, let's look at this, and this may explain better. What are we looking at? Isn't this a beautiful piece of property? This is the second house that Abraham Lincoln lived in as a child. The first house that his father built was lost in a title claim. Turns out the Lincoln family didn't actually own the land. This is the second Lincoln home. Lincoln's family also lost this one in a title claim. It was only the third one that Dad built that they actually got to keep. Why? Well, how do you know that you own a piece of property? You have a document called a deed. And sometimes deeds are recorded in the courthouse. But what if the person who owned the property gave out 2 deeds or 10 deeds or 50 deeds? Who actually owns it? There's all kinds of law on this. And back in those days, you had to rely on the opinion of a lawyer. And the lawyer would say, yep, you own it. And if you didn't own it or somebody else claimed that they owned it, what would you do as the landowner, the claimed landowner? Well, you had to go and find the lawyer who promised that you owned the property. Hopefully, the lawyer was still alive. Hopefully, the lawyer had some assets to defend you with. But often that didn't happen. And so people lost their properties even though they paid good money for it. And they got an opinion from some lawyer that they had ownership, but it didn't work out. So the title insurance industry came around to say, what the lawyers do is great, but we're going to set up a fund of money like every insurance company has. And if something goes wrong, you come to us. You don't have to go find the lawyer who's dead, drunk, or whatever. So title insurance checks the records, tries to clear the title, that is, find any potential problems or disputes or disagreements about the property and get those taken care of in a way that somebody truly does own their property. So we talked about some of the unique, or I talked about what some of the unique features are. We focus on what happened in the past. What is the record? What can we find out about the property? Where did it come from? Originally from the Penn land grant, but then how did the Penn family send it to the rest of the world and how did it get divided? And we try to prevent problems by clearing issues from the title search. One-time premium, we talked about that. And I think that every buyer needs to have title insurance. I don't say that because I have a title insurance agency. I say that because I would never buy a property without title insurance. I would never buy it from my father, my brother, my cousin. I would never buy it from anybody without having insurance. Why? Because there are things that even the owner of the property doesn't know, like the example I gave you where the person didn't know their own property was in a homeowners association. So how do you find that out? You have to search the record. Now, could you, if you really knew what you were doing, search the public records and maybe take the risk yourself? Okay. But I wouldn't. And if I have a client, whether they're a real estate client or a legal client, I tell them they need a title search. And what if they refuse? I'll go back to that in a minute. If they refuse to get title insurance, well, if you are not the broker, talk to your broker. If you are the broker, talk to your lawyer. I require a letter signed by my clients, the buyers, that says, we are waiving the opportunity to purchase title insurance. We're doing this fully knowledgeable. We are sane. We are over 21 years old. We know what we're doing. We're doing this against your best advice. And if something goes wrong with the title to the property, we are absolving you of any responsibility whatsoever, Mr. Grainer. Without that, I will withdraw from the transaction, but I will not be involved because when a title problem happens, and they don't happen very often, when a title problem happens, it's usually extraordinarily expensive or impossible to deal with. So this was just a deed that is signed by Martin Van Buren when he was president of the United States of America. What does that prove? Nothing. It's a deed. Does it mean the person who was deeded the property actually owns it now? Not necessarily. We don't know. It's life. There are mistakes that happen, and that's what title insurance is all about. So, we're going to talk about a thing called a title commitment. The title commitment is the document you get from a title company or their agent, which says if certain things happen and if you pay us a premium, we will issue you title insurance, which may have some exceptions on it, things that we're not going to insure, but that's the commitment of the title company that they're going to work with you. A title search means somebody goes to the courthouse and checks the public record. I have seen searches which are 3x5 cards or typed up um, 2 pages of notes that are hard to decipher. That's a search. A title report takes the search information and puts it in an organized fashion. Still not a commitment. I know that we use these things the same way in our business, but the commitment is really what you want. You want a title company to say, if you buyer and you seller do the following 973 things, we will insure the title and complete the settlement because that's what it's all about, right? Okay, so we will stop sharing that. Let me see if there are any questions. By the way, if I say something that doesn't make sense, it's okay. At least we'll try it this way. If you unmute yourself and say, Marshall, I have no idea what you just said, or I think you said it inside out and backwards. Um, it was Joe Frazier. Yes. Uh, let's see. New realtor here. So when a home buyer doesn't want to get title insurance, uh, yeah. When a buyer doesn't want to buy title insurance, they are making a mistake, in my view. And I don't know very many lawyers. I don't know that I know any lawyers who would recommend to somebody, don't get title insurance. As I said, I've seen problems when a parent transfers a property to a child, and the parent didn't know about certain liens and judgments and a mortgage that was there before the parent owned the property. There can be problems with inheritance. It just, I know that the premium looks like a lot of money. It is, but you pay it once. You can live in that property for 50 years. Somebody comes along and claims that their great grandmother owned that place. You will be insured against that risk. And to me, it's invaluable to have that. The cost of title insurance from all of the licensed agencies is set by the Commonwealth of Pennsylvania through a rating bureau. It's kind of weird. There are ways to get insurance for less if you buy it directly from an approved attorney. There aren't that many of those, but the rate should be exactly the same. And it depends on the purchase price. And then there are these addenda that you get as well. Anyway, let's jump into my horrible example. By the way, you have this uh, in the materials. You can download it. There's also some information from the American Land Title Association, what title insurance is all about. So this is a national form, the American Land Title Association. This is your commitment for title insurance. And there is, I think, 5 pages of boilerplate stuff that we are not going to read now because you would all be asleep before you finish your lunch. But this will tell you the kinds of things that you have to do to go through, to complete, to get to the settlement table, to make the sale transaction happen, so you get paid your commission, the seller gets paid their proceeds, and the buyer buys their house. So we're not going to pay attention to pretty much any of these. But again, these are some of the things that the title company has the right to tell you you have to do, and it also protects them. Okay, what you should land up with is something that looks like this. That's our title company, but whoever it is. And I've highlighted things for you in colors just so they stand out. So the first thing to note is the date. The commitment date is January 14. Today is March 24th. What happened to February and March? The answer is that the commitment date is the date that the title searcher was able to get the answers to the questions they needed to create this report for you. What happens if somebody put a mortgage on the property yesterday? Well, your title company needs to know when the settlement's going to happen. They like to have a little advance notice because they do what's called a bring down. They go back to the courthouse and they look for everything between January 14 and as close to today as possible to try to get rid of some of those risks. Number two, we have 3 buyers. We got Henry, Sally, and Lottie. How are they holding title? This is a question that you probably ask when you prepare the agreement of sale. If you got 2 owners or two buyers, are they owning as tenants in common, joint tenants with the right of survivorship? Are they married? In which case they can own as tenants by the entireties. If you don't know what those are, please refer back uh, to your learning materials from when you took your real estate course, because those are very important. How are they owning title? You will see that there's an amount of insurance that would normally be the purchase price. And there is going to be a loan policy if there's a lender, and most likely the lender will require title insurance even if the buyer doesn't want it. And in this case, BCAR Federal Credit Union is taking back a mortgage of $575,000. Question that I'm asked, why do I have to buy that extra? If the lender is forcing me to buy $575,000 of insurance, can't I just use that? Isn't that good enough? Why do I need to insure the full purchase price? And the answer is you can buy title insurance in any amount you want, but if you buy less than the value of the property, you are sharing the risk. That is, let's say that you buy insurance for half of the price of the property. You're buying a property for $1 million, you buy $500,000 worth of title insurance. The company's still going to do all the searching and do all the same get all the same information. If there's a loss, the title company will only pay half of that, and you're self-insuring, you'll be responsible for the other half. Is that good? I don't know. If you're the buyer, maybe you want to take that risk. So you can do that. What if you want to buy a $50 million policy? Well, you can only insure the amount of the value of the property. So the title people, even though they would make millions of dollars on the transaction, won't do that. So other information that will be on the title search and on this commitment schedule A is the name of the current owners of the property. I've had situations where the seller who signed the contract is not the title owner of the property. Now, that could be because of inheritance. It could be because they're the executor of an estate. It could be a mistake, or it could be fraud. And when you're in this business long enough, like I've been, I had that come up where somebody sold a property they did not own. And it wasn't until the title report, title search came in, that we found out that the seller was not the seller. Well, the seller was a seller, but that the actual seller had sold it to somebody else. And this was just somebody who came along and thought they'd make some quick money. So you need to read these things. It's not going to take you as long as it's taken me to talk about this one page, but just look it over and make sure everything makes sense to you. If it doesn't make sense, you stop and you call your friendly title agent and say, what's going on here? Might be a mistake, might be a problem. They're also going to put the address of the property, make sure it's the right property. This is Unit 162A in Lovers Retreat Condominium in Newtown. Okay, we're going to see that again coming up to us. Now, the stuff that we don't pay any attention to because it's in small print and it's very gray and there are no pictures. It says that all of the following requirements have to be met. Many of these are really simple. We need the SS numbers of the people who are involved in the transaction. How does that happen? There's a piece of paper called a buyer's affidavit or a seller's affidavit. Those are shared with you before the settlement, hopefully, and they get filled out. And the buyer or the seller signs, here's my SS number, here's my tax ID number for a business, really simple. If this is a condo, and it is, or if it's a homeowners association, somebody needs to know that all the fees have been paid. So they're asking. And there's a process for getting a resale certificate from the association, and that's simple. And in number 3, all the assessments have been paid, and the assessments for the current year, if they're not paid, are going to be an exception. Exception means we're not insuring it. The buyer or the seller, or both of them, are going to be responsible for it. Okay. All the condo documents in number 5 have to be reviewed by the association. Well, hopefully they figured that out. Number 6, you should start shivering in your boots. Evidence that Lovers Retreat Condominium Association has not exercised its right of first refusal. What is that? Some associations have a right of first refusal, which is the right for the association or their members, that is the neighbors, to match the deal. I just went through this with a commercial condo in Richboro. 35 owners have the right to match the purchase deal before you're allowed to go to closing. So, how does the title company know that that's in there? Somebody actually read the condo documents and they found the right of first refusal, which says that the owners get 35 days notice. So you have to send the agreement of sale to 35 owners and give them the right to buy the property under the same terms that you have here. Maybe the buyer wanted to settle really fast because it was a 1031 exchange or they need to move, but they're going to have to wait for at least 35 days from when the notice goes out because of the right of first refusal. Uh-oh. Read your title reports, your title commitments as soon as they land in your inbox. It's really important. Most associations do not have a right of first refusal. This one did. Child support is a problem because it takes priority over the ability to sell a property. What if people are involved in a divorce? You have to disclose that to the title company because there may be something in the divorce proceedings which gets involved and takes priority over the sale. Information on the marital status of the sellers, because again, if they're involved in a divorce proceeding, then maybe the proceeds don't go to them, it goes somewhere else. Let me see. Are there any things in the chat that I should be getting to?
There are a couple questions, Marshall.
Are there two types of title insurance? Yes, there's the regular policy and the enhanced property policy, which I think costs about 10% more and gives you a little bit more coverage. Uh, what if you have a seller? Yeah, what if you have a seller who wants to sell their house, but in the public records, the home is still in the parents' names? It depends. Oh, I hate that answer, don't you? But the lawyer always starts that way. It depends. Um, did the person who's trying to sell the property inherit it? Or are they one of six children and they just happen to be living there and they thought they could sell it? They have to do whatever it takes to transfer the property either from the estate to your buyer or from the estate to this person to your buyer. And you need to find out the lawyer who handled the estate has to get involved in that. And when and how do you get the title report? It usually comes electronically, which is great because there are ways to click on things and see neat documents. I suggest ordering it early on in the process. I know some people are worried that there's going to be a cancellation fee of 150 or 200 bucks, so they wait until after the home inspection, and they wait until after the home inspection is completed and you've gone back and forth and you've negotiated the $5,000 worth of repairs. I'll give you another quick story that illustrates why you need to do it quickly. Um, I had a couple come to me after they settled for their new home, and they were furious. They bought the house so they could build an Olympic-sized swimming pool in the backyard because their 5-year-old daughter was going to become an Olympic gold medal swimmer. I know, crazy, but that's life. Um, they only found out after they purchased the property, paid for it, got the mortgage, and moved in that there was a deed restriction against in-ground swimming pools. That is, in spite of the fact that they spent $750,000 and they spent months with their real estate agent, their buyer's agent, taking them from house to house looking for the right backyard in which to put the pool, nobody looked at the legal documents to see whether they could build there. Under the township ordinances, they could, but under the recorded deed restrictions, they could not. How would they know? The only way to know was to look at the public record and see what was recorded. So they were furious, and I think it's important. Yes, you want to do it as early on in the process as possible. These days, depending on where you are, the title search process can take a few days to maybe a few weeks. There is on the par form the right to get the title report as one of the inspections, and you can use that to cancel if you don't like it. Um, yes, the par form requires within 5 days of execution of the contract. The question is, does that actually happen? And oil and gas leases, I know nothing about, but yes, they would show up if they're recorded. But many leases, whether it's for oil and gas or just for renting an office or a pizza shop, are not recorded. Okay, I'm going to stop on that and focus back on the forms so we can get in what we need to discuss on those. Um, so you have to pay the title fee. There are going to be documents. The title company tells you exactly what they need. They need to see a deed from Rob and Laura Petrie, and the deed's going to go to the three buyers, and there's going to be a mortgage from the three buyers to the BCAR Federal Credit Union. And we would expect to see those. Mechanics liens. Mechanics liens are particularly nasty because mechanics liens can show up today and apply backwards up to 6 months. That means if the seller does work on the house and they don't pay the mechanic, they don't pay the people who did the work, and they just settle, the buyer will have a lien against their property that goes back to when the seller owned it, but it's on the buyer's property. It takes priority over the mortgage and their deed. That is, the buyer's going to have to pay it. Well, what do you do about mechanics liens? The answer is title companies are very nice. They believe people. And so on the seller's affidavit, it says, I have not done any work on the last 6 months that I haven't paid for. And by signing that and swearing to it and getting it notarized, it's now the seller's responsibility and the title company's responsibility and not the buyer and the mortgage company. So that's a really important one, that number 13. Um, if there are unrecorded leases, title company's not responsible for that. So if there's a tenant on the property, not their concern. Tenant gets to stay or leave depending on what the lease says, depending on what the buyer and seller say, but they're not responsible. Is everybody at least a full age and legally competent? Well, it's easy to prove your age. You provide some ID. Legally competent is harder. I may not be legally competent. I may be drunk. I may have Alzheimer's. Who knows? But again, they're going to meet you and take your sworn statement. What if there's a power of attorney? Please get the power of attorney, whether it's for the buyer or the seller, to the title agent as quickly as possible in the transaction. Don't let it be a surprise. Powers of attorney often have to be recorded with a deed if the seller is using it. It has to be in a proper form. The title company will not complete the transaction if you show up at settlement and say, oh, my client decided to take a cruise and they left yesterday and they're not reachable. And, here's a power of attorney they gave me. I can sign for them. Highly unlikely. By the way, you as a real estate licensee are not allowed to be given a power of attorney for a client in that transaction. If you do, you're subject to sanction by the Real Estate Commission. It is an absolute no-no. It's in the regs. Um, Okay, so we talked about divorces. Bankruptcy. What if somebody's in a bankruptcy? We have a real problem if the buyer is in bankruptcy, but it's way worse if it's the seller. If it's the buyer, most likely they won't get a mortgage unless it's a cash deal. But wow, what a problem. But let's start looking at where things can be hidden and you're not used to looking at them. Real estate taxes. Okay, typically somebody, the conveyancer, somebody's going to go to the taxing authority and get a 3-year look back. So have the taxes been paid for the current year and what about 2024 and 2025? Great. Okay. So somebody has to produce those receipts or a certification. And water, sewer, other things that are lienable, we have in most places water, sewer, electricity, gas are public utilities and they don't have a right to put a lien on the property. But if it's the Newtown Artesian Water Company or some of these others, they can lien the property. That's a problem. Note that I've highlighted it in red. This title search shows an unpaid bill from 2001 to 2005. What does that mean? That's ages ago. Well, sometimes the record will show a lien judgment, something on the record that doesn't make sense. If you see that, you need to ask. Don't assume that the buyer has any idea what they're doing. And in all honesty, don't assume that the buyer's lawyer, if there is one, knows that they're looking for this. If you see it, ask a question. It'll save you time and energy and problems at the settlement table. Okay, other things that the title searcher is going to look for, mechanics liens. Yeah, are there any that are already on the record? How about mortgages? So they found three mortgages on this property. Rob and Laura Petrie to Money Bank dated 2008. What do you do with a mortgage? Somebody has to go and get a mortgage payoff. Sometimes the seller has to do it themselves because the mortgage companies won't listen to the conveyancer or you as their agent or me as their lawyer. So you got to get a payoff statement that says loan has another $10,300, and that's wonderful. The second line item here is that Laura went to cash and carry loans in 2009. The mortgage was only recorded in 2011, but can one person who owns a property jointly go out and get a mortgage? The answer, as Anne Haley said, shaking her head, is no. You can't do that. Well, you can. I mean, look, if the lender is silly enough to give you the money, good for you. And the fact that they recorded it doesn't make a difference. It is kind of a problem though, because it's on the record, and the title company may have to insure over it. That is, kind of ignore it because you can't do that. But look at the third one. There's a mortgage for $6,150,000 from Envelopers Inc. to Core States Bank from 1989. What the heck? Um, well, remember Core States Bank? They were there before PNB or maybe after PNB and before Wells Fargo. Anyway, they were a major construction lender, and Envelopers Inc. could have been a wonderful home building company, and perhaps they had a $6 million loan to develop this 100-acre property. Why is the mortgage still there? Because nobody ever satisfied it of record. Now what? By the way, this happens a lot. Um, the title company is going to have to do something to get rid of it. Again, they can close their eyes and say, we will just ignore it, but we're not going to do anything. Or perhaps there's a way to find somebody at the bank. I know Core States isn't around anymore. Maybe it's possible for the title company to use certain rights they have under the law to go in and satisfy this themselves. But again, this is a surprise. You don't want to be learning about this the week of settlement. The sooner the better. And the title agent will look at it with you and say, okay, here's how we're going to handle it. Our problem. What about judgments? Not everybody is perfect, and sometimes there are judgments. Well, United States versus Sally Hyatt, there's a judgment for $14,850. If Sally was an owner of the property, then this judgment will attach to her share of the proceeds. Got to be paid. What about the IRS versus the estate of Howard Hyatt? That was Sally's poor departed. We're going to forget about the fact that she was sued. Well, they claimed she killed Howard, but we don't pay attention to that. Um, but there's a federal tax lien for $5 million. Well, so what? Unless Howard owned the property, this is irrelevant, and the title company will remove it. Jim Jones has a $600 very old judgment against Rob. Well, if Rob and Laura are married, tenants by the entireties, a Judgment against one of them does not apply to the property they own jointly, so that's going to disappear. And what about Wayne Manson versus Roberta Petrie? That's not Rob. That's not Laura. That's a mistake. It doesn't apply. It's not the same people. The title company will remove that. And Esmeralda Smoot versus Rob and Lauren. Well, somebody's going to have to sign an affidavit that says Laura is not also known as Lauren, and that one's going to go away as well. Not bad. Okay, there's going to be an owner's affidavit that the seller signs. There's going to be a buyer's affidavit that the buyer signs. Do read those. Sometimes they are wrong. Like if it says the sellers have performed work on the property and have paid for it in full, if they didn't pay in full and you represent the seller and you know that, have them correct it and give the truth, the whole truth, and nothing but. What other things might show up? This is just like 2 pages of the title commitment, right? There's a lot more, and we're going to jump really fast through the rest of it. Act 319, the clean and green rules. What if the property has clean and green on it? When you sell the property, there is going to be unpaid back taxes, recaptured taxes. Somebody has to agree to pay it. Is it going to be the seller or the buyer? If you didn't know about it, you probably didn't negotiate that in the contract. You may now have to go back and either say, okay, seller, to clear title, you have to get rid of this, or the buyer's going to be stuck with it. Not good. Schedule B section 2 is all of the exceptions to title, all the things that are going to remain on the record unless you can do something to get rid of them, and the buyer is going to live with for the rest of their ownership of the property. So anything that's recorded, defects, liens, encumbrances, all that stuff, if it's not something that they can find in the public record, and if you don't tell them, they don't know, in which case the buyer is stuck. How about claims of parties in possession? Again, if you have a lease or somebody is a squatter or they're claiming adverse possession, if it isn't in the record, the buyer's stuck with that. We talked about mechanics liens, easements, encroachments. You know, for some reason in our part of Pennsylvania, we don't get surveys on all the properties. If you're licensed in New Jersey, surveys are done all the time. Well, if there's a problem that a survey would have shown, title company is not going to deal with that, a boundary dispute or something else. So if a buyer is worried that they are not getting everything that they want to get, they ought to get a survey and make sure that they're getting everything they want to get. Number 7, there's a creek flowing through the property. Why do you care as the agent? Well, if the creek is really close to the house, maybe they need to get flood insurance. If the creek is 20 feet down below the level of the basement, then if the mortgage company requires flood insurance, maybe you can talk them out of it because there's no way this property is going to flood, even in the worst possible storm. Moving right ahead. There's all kinds of stuff that shows up. Philadelphia Electric Company, Bell Telephone Company. These are usually normal easements. But what does it actually say? Might it say that PECO is allowed to put a power substation on the property? It could. Does anybody ever read these things? Hopefully somebody who's interested in the property will take a look and see whether there's anything unusual. Normally it just says, we have the right to run our lines. What is the declaration in Deed Book 2790, page 723? I have no idea. Somebody recorded something. Anybody can record anything they want to against the property. So what is this? I don't know. How do you find out? Hopefully, there's a hot link on there and you can just click right on it and get to the document and the buyer can look at it, the buyer's mortgage can look at it, or the buyer's agent can look at it. What does it say? I will tell you this property has some really weird stuff on it. It has a condo declaration. It has another declaration that says that it restricts ownership and occupancy to legally married heterosexual adult individuals who are 25 years of age or older. What do we do with that? How do you get rid of it if you don't like it? The answer is, well, Act 54 that I worked on, but some of this stuff that gets recorded, like, well, you just kind of ignore it, but it stays on the record forever. Same thing with number 15, a 1903 deed restriction that says occupancy is limited and no resident may be of African or Asian descent and no person in residence may ever have been divorced. That last one might be legal. I'm not sure. Then there are conditions on a survey and conditions on an easement that's recorded. And then there's a driveway that goes through the property from 1884, and I'll bet you it doesn't exist anymore. But once something is on the public record, it tends to stay there forever. The last thing of importance that's on a title commitment is a legal description. You know, the meets and bounds description starting here, going there. When I bought my first house, I was really trying to show off to my wife, and I went out with the legal description and I started pacing it off. And when I ended up, we ended in the next door neighbor's property, which was very funny, but it was because the legal description was wrong and it was missing the fourth side of the rectangle. Again, we very rarely plot out these legal descriptions, and we very rarely get a surveyor to look at a residential property and tell us whether it's good. In this case, if we were doing a longer session, I would tell you there's a problem because this is a condominium unit, and condominium units don't get meets and bounds descriptions. They get, this is unit 162A in Lovers Retreat condominium, and you wouldn't get all this stuff because it's really irrelevant. So, knowing that we are running close on time, and I realize I ran through that really fast, let's look at some of the questions that have come up. And I guess maybe stop sharing the screen so I can look at some of your faces. Um, so, after the oil and gas thing, would the in-ground pool restriction be in Schedule B? It would be in Schedule B2, yes, but it might be restriction as in deed book page whatever. It won't necessarily say restriction against in-ground pools, because somebody would need to know that the 50 restrictions that are in that, only the in-ground pool is important to you. They're telling you there's some kind of a covenant. There's some kind of a declaration. Somebody recorded something. You're buying the property subject to that. So will the in-ground pool restriction be there? Yeah, sort of. There'll be information about a restriction. How do you get rid of it? Really good question. Um, in order to get rid of a deed restriction, you need one of two things. One is a court order. They do not happen very often, and they're expensive, and they take a long time. The other is everybody who has that same restriction has to release it from your property. So if it's a subdivision of 100 homes, you've got to go knocking on 99 doors. And even somebody who can't see your backyard might hold up and say, I don't want to, or pay me money. It's not easy to get rid of deed restrictions, which is why I don't like them, although I do use them. Um, I've seen quite a few churches sold and new homes built. How did the deed get changed? That wasn't a deed change. That's zoning and land use. You can convert a building to residential if the zoning allows it. You can convert a house to a commercial use if the zoning allows it. It's not, it could be something on the record, but usually it isn't. Do you have to order the attachments? Usually the title company will give you, as I said, these hot links right there so you can click on Deed Book 37 and it'll take you right to the documents. If the title company is lazy or very old-fashioned or maybe in a less progressive area of the state than Bucks or Montgomery counties or Philadelphia, you may have to ask them for the attachments. In the old days, we used to get a box of papers or envelopes of papers. Now you can do it all online, and it's really great. Um, where did the deed restrictions show up? I answered that. They are going to be in those attachments, those documents that affect the property, those restrictions. Would it show up in the MLS public records? I don't think so. Um, and whose job is it to sort all this out? Thank you, Stacy. That's the whole purpose of this. You, it's your problem. Whether you represent the buyer or the seller, you want the transaction to go smoothly. Don't rely on a conveyancer, a third-party servicing company, or somebody at another desk in your office. If you have desks in your office, if you have an office, you need to read this. You're the expert. You're the licensee. You have every right to go to the title company and say, I don't understand. Explain this to me. But if your buyer buys a property and gets surprised by something that was on the public record that you did not know about, as the buyer or seller's representative, it will come back and bite you. Does it happen often? No. Does it happen? Yes. I want to save you from being one of those that it happens to. If you're buying or selling a property, you find out somebody has been taking care of a section of the property for 20 years. Adverse possession question, Stephen. Um, you immediately give them permission to continue to use the property, or you tell them to stop, one or the other. Adverse possession, after 21 years of open, notorious, continuous use of a property, you can claim it and go to court and get it given to you, maybe. If you give somebody permission to use the property, then you take away that adverse, the argument part of it. Can I answer the questions of how to address outdated illegal restrictions? Okay. If the restrictions are illegal under the Federal Fair Housing Act or the Pennsylvania Human Relations Act, Act 54 of 2023 that I was the sponsor of or helped to write, nullifies those things. So if they're illegal, if they're racial or they're based on marital status or having children, except for 55 and over communities, those things are gone. You can ignore them by virtue of this new law. Other things that may be archaic, um, yeah, you're stuck with them. The fact that somebody had a driveway on the property in 1884, that driveway is still there as a restriction unless you can get it gone. And that will involve a lot of time and money and legal fees and court costs, and you probably don't want to do that. Yes, the governor is involved in some kind of a dispute. I haven't read all about it with a neighbor over adverse possession or location of offense or something. That's not a title issue. The title company says, unless you get a survey, we're not responsible for boundary lines. So neither Governor Shapiro nor his next door neighbor can go to their title company and say, defend this or prosecute it or kick them off the property because it's not a title issue. Um, can you put a buyer and title company in touch with each other? Sure thing. Absolutely. But and the buyer gets to choose the title agent. Remember that? So it's their agency. They've got a direct relationship to them. They absolutely should talk if they've got concerns, not a problem. Sometimes they need you to kind of be the intermediary because a lot of buyers don't understand this stuff. Gina, I skipped your question. Do I recommend listing agents ask sellers to get a title search prior to the listing? You know, I've never done that, but what I have done is I've asked the seller to give me the search from when they bought if they have it. Um, I hate to have people go out and spend money and
You
do
know why?
things.
You know
Yeah.
why I asked that?
Mhm. Go ahead.
My last deal that was supposed to happen was November 21st. It was a title issue. That's why I registered for this webinar. It
Mhm.
really took me a while to get over this. I'm a new agent. I'm going in my third year. And what happened? We were just waiting for the settlement date. The settlement notice went out to the listing agent. He was ghosting me. I'm getting nervous. I called a listing agent. I'm like, hey, what's up? He goes, the seller has issue. Her brother popped up on the title. Uh-huh, uh-huh. So I
Mm-hmm.
go, I'm a new Jack. So I go, what does that mean? And so I had to go tell the buyer we don't have a settlement date because seller has issues. So 3 more weeks went by. I'm a new Jack. I'm like, should I call him? Whatever, whatever. I finally call the listing agent. He goes, they both lawyered up, and the brother that popped up on the title doesn't even want to speak to me. And I had to
Mm-hmm.
terminate and release the earnest money back to the buyer who has lost all
Yep.
faith in me, thought I was scamming her. Oh my God.
Yep. And that is a problem, especially where you've got multi-generations, where a lot of people do these. They want to avoid probate for some reason, which really doesn't mean very much. So they put a property in the name of the parent and all the children. And then when the parent dies, all the children own it, but one is in North Carolina and one is in Guam and one nobody knows where they are, but all six of them own the property. Now you got to get all six of them to sell, even though one's been living there forever. It's a bad situation. You certainly can ask the seller to do a title search before you list the property. If you have a concern, if you've got a gut feeling, um, there's a question here about are HOA restrictions for PUDs recorded? Yeah, I hate the term PUD. It's a planned community, but yes, condominium, homeowners associations, the restrictive covenants are recorded. Bylaws are not. Rules and regulations are not. So I see we're at the witching hour. It's 1 o'clock. Time goes by really fast for me when I'm talking. Um, Hopefully, this has been helpful to some of you. If nothing else, I've given you the warning that you need to take a step back. Next transaction you're involved in, spend a little time reading the title search. If nothing else, it'll help you get some sleep if you have insomnia. But pay attention. It's your responsibility. You're going to make a decent income on this transaction, whether you represent seller or buyer. That's what you're here for. We all want to make money and we all want to avoid being sued. So spend the extra time, ask questions. Your title agent would be way happier to answer it today for a June settlement than the night before the closing. And with that, Lisa, back to you.
Yeah, thank you, Marshall. This has been extremely helpful.